Now, one of the things that I'm involved with right now is working here at the Marriage Tribunal for the Diocese of Beaumont. And at the tribunal, what we're doing is examining marriages with a view toward determining whether or not they are invalid. Everyone in the church has the right to know what their legal status is. Am I a person who's bound by the consent exchanged and therefore am married, or am I someone who is not bound by marriage and therefore free to marry? That determination is something which is left to the matrimonial tribunal. The Code of Canon Law is very clear in telling us that all marriages are presumed to be legally valid until they are proven otherwise. All marriages. So it doesn't matter if an Episcopalian marries a Methodist, we're going to understand that as being a valid sacramental marriage. It doesn't matter if you have a Muslim who's married to a Hindu. We're going to presume that that marriage is also a valid marriage. And we're going to protect all marriages with the law until we prove the otherwise. That's the task of the tribunal, is to determine the validity or invalidity of a marriage. Now, yesterday, or the last time we spoke, I mentioned some words that we sometimes use, and maybe loosely. So we don't have vows at weddings, and we don't have wedding ceremonies. We exchange consent, and we have wedding liturgies. People will often say, I need an annulment from the church in order to get married again. Well, no, you need a declaration of nullity. To annul means to dissolve. The church is not dissolving marriages. That's what your divorce does. A divorce is the state saying you were lawfully married and therefore bound by the contractual obligations of marriage. This marriage is now dissolved by the state, and you are free from the legal bounds and restrictions that were imposed upon you by the state when you entered into marriage. We don't dissolve marriages. What we do in the study of a marriage is to determine whether or not the marriage is canonically valid. The process then is very much of a trial. And what's on trial are not the parties. We're not trying to find someone guilty or someone innocent or someone responsible and someone not responsible for what happened. It's the I do which is on trial. What we said in a previous recording was that marriage comes into being by the lawfully manifested consent of persons capable of doing so. What the process of nullity is saying is there was something flawed in the consent. For some reason, the I do did not permit the partnership of life and love, which is permanent and indissoluble, from coming into being. The Declaration of Nullity never says you were not married. The state says you were married. We're going to recognize that you were married. So we're not saying with the Declaration of Nullity you were never married. What the Declaration of Nullity is saying is because of a defect of consent, marriage as the church understands it did not come into being. And so therefore, the parties would be free to enter into a new marriage. So what might be a defective consent? Well, here's a good example. I'm standing in front of the altar and I'm about to say, I take you to be my wife, except the problem is I'm 17 years old, and the bride standing next to me is 15 years old, and we've discovered that she's pregnant, and her daddy found out she's pregnant, and her daddy is sitting there in the front row, and he's got a Glock tucked under the cummerbund of his tuxedo. I have to ask, am I free, truly free, to say I want to marry you? I think we would all agree that in this case, he's being forced into this marriage and is probably living with a great deal of fear. That's clearly a defective consent. And the church has myriad other examples of what constitutes the defective consent, for which we will explore those in a later session.